This masterclass is going to be about directors' duties and a developing area of the law which I think probably quite a few people aren't aware of. I deal a lot of the time with directors when they have been acting on behalf of companies that have become insolvent. And often directors are the target of litigation by liquidators, either under Section 214 of the Insolvency Act or 213 of the Insolvency Act and other provisions of the Insolvency Act, whereby the liquidator seeks to recover money from the directors in relation to various liabilities. But when that money is recovered, it's recovered for the benefit of all creditors rather than just one or more individual creditors. And the area that I want to focus on today is an area where individual creditors can take action against the director and recover damages in relation to statements made by a director in the sort of dying days of a company, which are dishonest statements and which are relied on by a creditor. My name's Lexa Hilliard and I'm a silk at 11 Stone Buildings, and the area that I specialise in is insolvency law, company law, often involving directors' duties, professional negligence and general commercial litigation. The developing area of case law that I want to refer to concerns the Statute of Frauds Amendment Act 1828, otherwise known as Lord Tenterden's Act. Now, some of you probably aware of the Statute of Frauds Act 1677, and in particular Section 4, which requires a guarantee to be signed and in writing for it to become enforceable. Now, how the Statute of Frauds Act came about was because the courts, it wasn't that they were interested in protecting poor benighted individuals that guaranteed liabilities orally. That wasn't the concern. What the concerns was that the courts were utterly clogged up with people coming to court and saying, he guaranteed this liability and I want to be paid for it. Whereas the defendant was saying, no, I didn't. And so that you'd have this kind of, yes, you did, no, I didn't type of debate in court. And the courts were just being clogged up. So what the 1677 Statute of Fraud Act, Section 4 was designed to do was to stop that. The way it was stopped is that the law said is unless a guarantee was in writing and signed, it wouldn't be enforceable. Lord Tenterden's Act, which was came into force a couple of centuries later, that was concerned with a similar problem, namely you would get people that made representations about the credit, the character, the dealings or affairs of a third party in order to obtain goods or money. And again, those representations were oral, and Lord Tenterden's Act was introduced to say that you could only enforce those representations if the representation was in writing and signed. Now, Lord Tenterden, just as a bit of an aside, was Chief Justice Abbott before he was Lord Tenterden. Then he was made Lord Tenterden, and he took a really very keen interest in this particular act. But I think he's quite an interesting person because he was the son of a barber, which, I mean, even in those days, I mean, you know, quite a long time ago, it shows that actually the courts were quite diverse, unlike perhaps the courts now, whereas I think probably in our higher judiciary, there's probably not a judge that was the son or a daughter of a barber or someone of the working classes. I think that's quite an interesting piece of information.